I'm Alex Berger from Berger Law in Marquette, Michigan. Today I will be talking about preliminary examinations. Whenever anyone's charged with a felony in the state of Michigan, they have the right to a preliminary examination within 21 days of their first court appearance. Preliminary examination is where the prosecution has to put on enough evidence to show that there is probable cause that the felony was committed and that you are the one who committed it. Back in merry old England, in the beginning of our common law system, they used to have what's called grand juries, and they still have these sometimes in federal court and in state courts. But the purpose of a grand jury is to figure out if there's probable cause that you committed the crime. A preliminary examination is just a condensed, sped up version of that. It's a chance for the judge to decide if there's enough evidence to move forward with the felony charge. So these hearings, they are evidentiary hearings, meaning that the prosecution actually calls witnesses to come in and put on evidence to show documents that you are in fact the person that committed the felony and that you committed the felony. So it is a great opportunity in a lot of cases. Now, a couple of things about preliminary examinations. Number one, they're supposed to happen within 21 days of your first court appearance, but a lot of times they get postponed for a variety of reasons, including that your attorney needs to look at the evidence and they haven't gotten the evidence yet. But just because it's supposed to happen quickly does not mean it necessarily happens quickly. It can be months and months and months before you actually have it. Next, most felony cases do not actually have the preliminary examination because the defendant waives it. There are a number of reasons you might waive a preliminary examination. First, they might be making a plea offer that's really attractive and you want to think about, but if you have the preliminary examination, they will withdraw the plea offer. Number two, it might be a case where you just have an officer testifying that say they found some drugs on you, and having the preliminary examination would just give that officer an opportunity to refresh their recollection, and you won't get any additional information out of them. And number three, sometimes people waive their preliminary examinations just to move the case along. They want to get to a resolution, they want to get it done, and having it would just delay that. So in most cases, you don't actually have it. You just waive it. But in a lot of cases, you do have them. And here are some reasons why you might want to actually run the preliminary examination. Number one, if you might win it. Because it's such a low standard, it's probable cause. Basically, they have to show that a reasonable person would entertain a belief that you committed the crime. Which is a really low standard. So they win almost all of them. You don't get to put on a defense, so you really don't get to argue against it much. But there are cases where the crime just isn't there. Law enforcement's wrong. One of their witnesses is not going to say what they think they're going to say. So we run preliminary examinations when we think we might win. Now, that being said, if you win a preliminary examination, the prosecution can just refile the charges. There is no double jeopardy or anything like that with preliminary examinations. If they lose, they can just try again, over and over again, unfortunately. The next reason, and the far more common reason that we run preliminary examinations, is because it's a great opportunity to get evidence, particularly in an allegation where there is a supposed victim, someone who's claiming that you did something. Having an experienced attorney cross-examine that person relatively early in the case to lock in inconsistencies, to lock in lies, to lock in problematic disclosures or biases is critical. That evidence is so helpful if you're going to proceed to a jury trial. All of the best attorneys I've seen in the state of Michigan have that transcript from that preliminary examination when they are at trial, and it is one of the most devastating tools for finding the truth, pointing out lies. So in any situation where you might actually go to trial and there is an actual non-law enforcement witness, having that preliminary examination to cross-examine that witness and get that evidence is critical. So that's kind of what to expect. I've seen preliminary examinations take 15 minutes, and I've seen them take days. So it all depends on the complexity of your case. You will not need to do much the preliminary examination except for sit there and listen and take notes. All right, thank you.